I'm Jen Shaw. We spend our days helping employers sort through messy workplace situations, often in real time and often with a lot on the line. On this podcast, we'll walk through those issues, what's coming up, what actually matters, where employers get into trouble, and what to do next. No theory, just practical guidance you can use. The time is flying. As you guys know, Ella's going to be a junior in high school this year. I can't believe it. It's just crazy. I mean, she's literally going to start school in a month. Okay, whatever. I cannot focus on that. What I am going to focus on today is helping you understand why the first 24 hours after an employee raises a concern or makes a complaint are so important. Okay? Every workplace complaint or issue or concern that is raised represents a decision point. Handled well, it may never become another issue. Handled poorly, it may result in litigation. So I want to talk today about those first critical 24 hours. So somebody raises an issue, and it might be a written, ethics complaint. It might be something somebody puts in an email. It might be anonymous, whatever. We're just going to call it a complaint. When you receive a complaint, if you know who it's from, which most of the time you will, 2 magic words you always want to say: thank you. That does not mean you agree with the complaint. Doesn't mean you think the concern's valid. Doesn't mean you are going to do something. It just means I appreciate you following our policy and coming to me directly. That's what we're talking about, okay? So 2 magic words: thank you. Second thing I want you to think about when somebody comes to you or you become aware of an issue, concern, complaint is listening. Okay, and I want you to understand and remember, we all know this intellectually, but there is a difference between listening and hearing. You can hear things that you choose to ignore, right? There can be rumbling going on in the background. My computer right now is making noise, but I'm ignoring it. Listening means you are engaged. You're actively listening. You're not multitasking. You're not looking at your phone. You're not looking at your desk. You're not reading an email while somebody's speaking to you. You have to listen. Now, one of the hardest things when somebody brings you a concern or an issue or a complaint is not making promises. What you want to do is say, oh my gosh, thank you so much for coming to me. I'm so glad you're trusting me with this. I want to just listen to everything you have to say. And I promise you, if we find that something happened, we will fire Matilda, right? That you might be tempted to say, like, we're going to throw the book at him because you want to show you care. But the problem is you're making promises that you might not be able to fulfill. And that's going to be a problem for you down the road. You don't want to make promises one way or the other. You also don't want to tell the respondent or the accused in an investigation, hey, don't worry about it. I got to do this investigation, but I promise you, you're going to be fine. Not the approach you want to be taking. You want to make sure you remind the individual who comes to you or who sent you something, hey, you're protected against retaliation. So you cannot be treated differently in a negative way because you made this complaint. You also can't treat anybody else differently in a negative way because you made this complaint. In other words, you can't try to stir up the whole workplace against the respondent or the accused. So you've got to talk about retaliation. You want to think immediately about preserving evidence. So last week we talked about documentation. You want to make darn sure that if somebody is documenting in an email system, that those emails are not going to be automatically destroyed as part of your document destruction protocols. So you have to make sure you're preserving the evidence. You want to think as the person is telling you what's going on, or you're reading what's going on, or you're evaluating the situation, is there anything I need to do right now? Before I figure out what happened, maybe I have to do an investigation. Maybe I have to talk to a few people. Before I do that, is there anything I need to do to protect the individuals right now? So If somebody complains that one of their coworkers has touched them inappropriately, you might not want them working together while you're doing the investigation, because that's pretty risky if the accused decides to continue that behavior, if that's what they've been doing, right? On the other hand, if it's a complaint that somebody didn't get a promotion, they're not alleging any harassment or any inappropriate conduct. They just think they were unfairly denied a promotion, which is a very important complaint, but it doesn't raise the same physical concerns as the first scenario. So you may not need to send anybody home at that point. If you don't know what happened, all right, if there's something you need to know that you don't know, you need to do an investigation. You've got to decide, are you going to do it internally? Are you going to do it externally? Who is going to be in charge of the investigation? How are you going to set it up? What are you going to communicate about the investigation? And to whom are you going to communicate? How are you going to follow up, right? How are you going to make sure at the end of the investigation, you let everybody know, all right, this is what happened. This is what we're going to do. These are the next steps. All of these issues are going to come up for you in the first 24 hours, which means you have to have a protocol, a policy, a plan in place before that ever happens. So that once it's clear that there's something you're going to need to look into, somebody's raised a complaint, now you can say, okay, I'm ready to roll, right? Now I got to figure out what's going on here. And I've got all these things I need to do. I need to listen. I need to say thank you. I need to make sure that I am figuring out if I need an investigation and who's going to do the investigation. All of these issues. So what are the mistakes we commonly make in those first 24 hours? Right? Well, first of all, we don't do anything in the first 24 hours because we're too busy. Well, there's nothing more important on your plate unless there's a safety issue than an employee complaint, right? You talk too much rather than listening. You don't document what people are telling you. You can't do an investigation, for example, without taking notes. You can't have a conversation with an employee without taking notes. You've got to be able to document what happened. And I think it's interesting to me why we don't do a better job with this part of the process, right? And I think we just get overwhelmed. We get busy. We know we should be taking notes, but we're worried that the person just wants us to talk to them. We don't actually understand what we're supposed to be doing. It's difficult, all right? And I understand that. But that's why if you have a protocol in place up front for what you're going to do during those first 24 hours, then you can check the boxes. You can literally go down and say, okay, I've done all these things. I find checklists to be very helpful. I've got all the information in my head, but sometimes when there's a tricky situation that has come up that I need to deal with, I want to make sure I have a checklist so I don't leave anything out of the process, right? I make sure that I'm doing everything I need to do. Another mistake you can make during those first 24 hours is telling too many people what's going on. You feel the need to explain. You don't need to explain to anybody, right? Only people who literally need to know, not who want to know, who think they need to know, but who actually need to know. And that's going to be a pretty small group of people, all right? So you don't want to look like you're taking sides. You don't want to try to sort of, gather support one way or the other. If somebody's come to you as their HR professional or their EEO officer or the owner of the business and they want you to look into something, you have to be fair. You have to be impartial. You have to have an open mind until you are done dealing with the situation, right? And by that, I mean you have investigated it. You have figured out what you think is more likely than not to have occurred. Remember, you're very rarely going to know for sure what happened. And if you do know for sure what happened, you didn't need to do an investigation, right? Because you only do an investigation when there's something you need to know that you don't already know. When you think about this first 24 hours, understand that you are under the microscope. The employees are watching you. If the matter goes further, to the EEOC or the Civil Rights Department, or they go get a lawyer, they're going to be evaluating what you did in the first 24 hours. So the situation is really critical in that first time period, because you've got to lock down any gossip or discussion. You've got to make sure you're initiating the conversations. There's just a lot you have to do there to try to get the situation handled. All right, that's what you need to do when you're looking at those first 24 hours. Now, it may take you a while to wrap everything up, right? You may not be able to get all the information you need. You may need somebody to come back from a leave of absence. There may be a lot of things going on, but those first 24 hours, I want you to imagine that you have a reporter following you for those first 24 hours. And they're going to write down everything you do and do not do, and everything you say and do not say, right? So they're looking to make sure you're discreet, you're fair, you're actually not making fun of anybody who's involved, right? I mean, I cannot tell you, in the 30 plus years I've done this, the number of times that a lawsuit is actually because of what happened after the incident that the person complained about. The initial incident wasn't so bad, but it's what we did later, right? It's what the actions the employer took after the fact that really create the problem. So the first 24 hours are a critical period, and I want you to plan it out very carefully. You need to have a checklist that helps you remember, okay, what am I supposed to be doing? What am I looking for? What am I making sure doesn't happen, like the destruction of evidence, right? All of these issues need to be top of mind for you. And then after the first 24 hours, you're going to have a lot more information. You're going to know what to do, and you're going to be able to move along in a very efficient way. But if your hair's on fire when somebody comes to you and you don't have a plan and you don't have a strategy and you don't know what you're supposed to be doing, you have very little chance of doing it correctly, because it's very hard to process something this complicated in the moment. You need to have it available, and all of your leaders need to be trained on it, and your employees need to know what to expect. That is what you do in the first 24 hours. Now, I want to talk to you about one of our employer's lawyer resources called Office Hours. And Office Hours is one of my absolute favorite things Joe and I do every week. Twice a week for an hour, Joe and I host a live discussion on a timely California employment law topic. We provide practical guidance that our clients can put to work immediately, and we answer their questions in real time. And the premium and signature clients participate in this live, and then they can request a one-on-one privileged conversation in our vault on Zoom to let us know whatever they need. Okay, and all that is included in their $300 a month or their $600 a month. Why are we doing this? Because we care about HR, because we care about workplaces, because we want employers who don't always have access to affordable, experienced counsel to be able to get the advice and counsel they need to solve their problems. Okay, we don't do investigations at Employers Lawyer. We don't do live training of employees at Employers Lawyer. We give advice and counsel. We help employers in every industry, all over the place, figure out what they need to be doing to stay on the right side of the law. Now, to learn more about Employers Lawyer, you can go to employerslawyer.com. Also, of course, follow us on LinkedIn. So, what is your practical step I want you to take this week? What do I want you to do? Very simple. I want you to pretend you're an employee, and I want you to walk through your internal complaint process. Go through it step by step. Who do you tell? What does the policy say? What happens when you go to that person to let them know what's going on, right? You go to HR or the VP of operations or whoever it may be. Walk through it step by step with a critical eye, with the mind of a plaintiff's lawyer, and think about where your opportunities are. I know you've got them. We all do. Nobody is perfect. We're not going to have all of this figured out. But I want you to look at it and really be critical of what you can do better and then fix it, right? Because remember, you guys, the first conversation after a complaint often matters more than the last one. Even if somebody doesn't agree with your finding, your factual finding in an investigation, for example, if you respected them enough to meet with them immediately, to listen to them, to explain the no retaliation policy, to do all of that, they're more likely to accept your finding at the end of the investigation, no matter how it comes out, right? Somebody's going to be upset about it and somebody's going to be happy about it, and that's fine. So take some time to look at your complaint process, figure out what you need to be doing differently or what you can improve, and then do it. That's your very simple homework for the week. Everybody, have a great rest of your day. I hope it is beautiful and sunny and gorgeous where you are. It certainly is here in Sacramento. Have a wonderful rest of your week, and I will see you next Wednesday morning, bright and early. Shaw Law Group, we solve workplace problems. Real-world guidance for real workplace decisions. The Workplace Wake Up podcast is produced for general educational and informational purposes only. The views expressed are those of the speakers and do not constitute legal advice or create an attorney-client relationship. The law is complex and constantly changing. Therefore, you should contact an employment lawyer in your jurisdiction for advice regarding your specific situation.